All right, let's dive right in. Today, we're deconstructing the UK's pivotal 1988 Immigration Act. This one's a big deal because it introduced some major legal shifts that fundamentally reshaped the country's entire approach to immigration.
So you gotta understand, this wasn't just some minor tweak to the 1971 law. No, this was a fundamental overhaul. It dramatically changed the rulebook on who could enter the UK, who could stay, and how those rights were enforced, really setting the stage for decades of policy that followed. Okay, so here's our game plan. We're gonna break down 6 key changes. The end of those pre-1973 protections for Commonwealth citizens, new rules for polygamous marriages, a whole new definition for overstaying, much stricter rules for proving you have the right of abode, and finally this landmark exemption for European nationals. Let's get into it. First up, let's talk about the repeal of a really key protection. The Act basically removed a long-standing safeguard for Commonwealth citizens who had settled in the UK way back before 1973, and it completely changed their legal standing. The change was pretty significant. You see, before 1988, there was this kind of, well, you could call it a grandfather clause in the 1971 Act that protected the families of these early Commonwealth settlers. But the 1988 Act just stripped that safeguard away. Now, the idea might have been to create a single set of rules for everyone, but the effect was that these long-settled families were suddenly exposed to deportation rules they'd previously been shielded from. And the way they wrote it, the legal language here is just so blunt, so final. Is hereby repealed. That's it. No ambiguity. This one little line subjected everyone, no matter what their historical connection was to the UK, to a single, much more stringent set of immigration rules from that point on. Okay, next, the Act took aim at family settlement rights, and it got very specific, targeting polygamous marriages with a whole new, restrictive set of conditions. So what Section 2 did was establish what was essentially a one-wife-only rule for settlement. It meant that in a polygamous marriage, only one wife could claim the right of abode. If another wife of the same husband was already in the UK, or even if she'd just been given permission to enter, that was it. No others could follow. And the legal drafting here was absolutely key. The Act defined polygamous very, very broadly. A marriage was considered polygamous if it was simply the type of marriage that allowed for more than one spouse. It didn't even matter if the husband never actually had another wife. This was clearly designed to give the new restrictions the maximum possible reach, closing off any potential loopholes. Now, this next change was huge. The Act didn't just tweak the rules around staying past your visa's expiry date, it completely redefined the offense itself. This was a real game changer.
You see, before 1988, the offense of overstaying was considered to happen on the single day a person's leave expired. That meant prosecutors had a limited time window, usually just a few years, to bring a case. If the authorities didn't act fast enough, it could become legally impossible to prosecute someone for staying in the country unlawfully.
And here's exactly how they closed that loophole. Section 6 redefined overstaying as a continuing offense. What that meant was the crime wasn't a single event anymore, it was something you were committing every single day you remained in the UK without permission. Suddenly, that time limit, the statute of limitations, was no longer a problem, which gave immigration authorities much, much stronger enforcement powers.
So the Act didn't just change the rules for entry. It also got a lot stricter on how you proved you had the right to be here in the first place. The burden of proof was suddenly much more narrow and way more specific. Section 3 really tightened the rules on evidence in a big way. Before this, the requirements were a bit less specific, which could cause confusion at the border. But the 1988 Act made it crystal clear. If you wanted to prove your right of abode, you needed one of two things: either a specific UK passport that describes you as a British citizen, or an official government-issued certificate of entitlement. This standardized the whole process and put the full burden of proof right on the individual. Now, amidst all these new restrictions, the 1988 Act did something else pretty incredible. It created a completely distinct and separate path for a specific group of people, and it really reflected the UK's growing integration with Europe at the time. The Act officially put into law a unique status for nationals of the European community, which was, the precursor to the EU. So while the rules were tightening for pretty much everyone else, a parallel, much more lenient system was being cemented in UK law just for EC nationals. And this right here is a pivotal moment. Section 7 wrote European free movement directly into UK law. It stated that nationals from the European community who were exercising their treaty rights, like working or starting a business, were completely exempt from UK immigration control. They did not need permission to enter or to stay.
This is what officially created a two-track immigration system, one for Europeans and a different one for everyone else.
So let's just recap. The 1988 Act was really a story of two opposing forces. On the one hand, it tightened the screws on general immigration. It removed historical protections, it restricted family rights, and it closed legal loopholes. But at the very same time, it opened a separate, much wider door for European nationals, embedding that principle of free movement directly into UK law.
And this dual-track approach, this idea of restriction and exemption, of creating different rules for different groups of people, it really set a precedent. It established a legislative framework whose echoes are clearly visible in the complex and often contentious debates we have surrounding UK immigration policy to this very day.